I'm very familiar with Judge Gonzalez. I have tremendous respect for her. We're not saying no to Judge Gonzalez.
And we are going to start with pages 3 through 6, State of Nevada versus TikTok. And I have appearances on behalf of the state of Nevada, please.
Sure. Good morning, Your Honor. Michael Gahan on behalf of the state of Nevada. Also with me in court is Samantha Feely from the Attorney General's office, Richard High from my office at Claggett Sykes, and Phil Carlson from the Notchawati Law Group. Also observing only on Zoom right now, it looks like we have co-counsel Raquel Fulgham from the AG's office, and then all from the Notchawati firm, Matt Bush, Brian Moore, and Dory Tisson.
Okay, and then the last name that's showing up there, remember ONJ, I believe, remember this is subject to immediate request, and so same reminder that I remind people, because like I said, sometimes people don't see it when it's somebody appearing remote, that if there's anything that would fall within your confidentiality stipulation, to let the court know, and then I can address it that time if that occurs.
Thank you.
Yes.
I don't, and I do see Christian Barton from the Morris Sullivan Lemkel and Kurtzo firm just joined, and I don't anticipate any confidential or sealed information coming up today.
Okay, thank you. Counsel for defendant, go ahead, please.
Good morning, Your Honor. Colby Williams on behalf of the defendants.
Okay, and you don't have your.
I'm solo, Your Honor.
Okay, no worries. Just want to make sure we weren't starting in case you had anybody else. Okay, so what's on for today is there's two things. We have plaintiff state of Nevada's motion for an order appointing a special master, document 182, defendant's opposition, document 189, plaintiff state of Nevada's reply, document 191, all timely filed. Okay, so counsels, thinking about a way to address this particular hearing, because you all as very experienced counsel who regularly practice in business court and regularly handle cases on a larger scale, right? First time I've had somebody object to a special master appointment in these type of cases. I mean, I've had it in cases where, you know, there's been a large financial component with very small companies.
Sure.
But I must admit, I can't think, I shouldn't say I haven't, I can't think of any I've had in a decade-ish. Okay, so realistically, where I was trying to get is to heart of the matter. Okay, and so I'm going to kind of ask some generalized questions. I'm going to tell you in advance, you do not need to answer my questions, okay, because you might view that it's your strategy. And so I have no objection to not answering my questions, but I'm really just trying to get to the heart of it. I'm trying to get an understanding if there's really an issue about a special master, or if it's an issue related to other issues that might be pending in the appellate courts, and nobody wants to have it viewed that somebody's conceding some other point that could be utilized in the appellate process. Because if it's the latter, I could see ways that it can be addressed, right? And you might have some 7.50 stipulations. If it's the former, in reading your briefs, I would have some questions, right? Because I mean, while I do appreciate there's cases from before when some of you were born, cited, right? There's cases from Kansas, there's cases from the Northern District of Illinois. There is citations to articles from February of 2025, citing an interpretation of testimony potentially given in the legislature. But when I look at the heart of 53 and its purposes, I might have some questions, so I'll leave it at that. And like I said, so there is a question bundled in what I just said, because if the issue is, I'm trying to phrase this in the most nice and neutral way, is that there are other avenues, and people have other avenues that they need to address, a whole bunch of different things, right? Then maybe we can find a way to work on that and make sure the best interest of the case, okay? And if it really is special master, you do appreciate that I'm going to be asking you all questions such as how many pages you think of like documents that might be coming before the court, whether it's in pages or whether it's in bytes, right? Terabytes possibly. And I'm going to be asking how much time each side has kind of thought about that you might need court assistance, in no way waiving anybody's arguments about whether or not you should even be here today. And I'm in no way addressing anything that is being handled down the street, okay? But I've got to walk through some of those because in the absence of a special master, then I will be potentially maybe seeing you all a lot, or maybe I'm going to hear an affirmative statement as officers of the court that you don't plan to have hardly any discovery disputes. And if so, they're going to be very short with very few documents and exhibits, and that you all are going to be willing to be here as we walk through each and every one of them. Or the reason why it seems I've not had some special master issues in the past is because usually the councils like the idea of having either, what do you call it, two chances to, you know what I mean? Going first before a special master, and then the standards that a district court judge looks at it. Or sometimes they like the ease of, this is what people express to me, right? They like the ease of doing more informal letter briefs, whereas, yes, I'm aware of a letter from September 5th, but you're aware I'm a district court judge and court has to deal with motions and doesn't really have that same flexibility that a special master might have in dealing with the informal process of letters. Sometimes people tell me that they want to utilize depositions from other cases and that they may have objections to depositions, and then they don't necessarily want to be in court going line by line, paying their very sophisticated attorneys as we go over it, line by line for line, possibly for days on end. Example, what was going to be occurring in the opioid, that's a specific example. Then they agreed in that case they want a special master and handle it because it had flexibility issues. Okay, so that's not in any way any tea leaf interpretation. Is not really an inclination. It's really a what makes sense for this case kind of question. And if you'd rather just give your oral arguments and bundle in what you want to do, I'm perfectly fine with that. And then I would ask counsel for the move it to go first, and I'd ask opposing counsel to go next. If you want to take a few moments and talk among yourselves and anybody else that you need to talk on online, and you want to evaluate that, then the court's going to be okay with that as well. So why don't you let me know what you would like to do?
Yes, you want me to start?
No,
I'll start here.
I'll start. Thank you, Your Honor.
Go ahead.
Again, for the record, Michael Gain for the state of Nevada. Appreciate the court's comments, and in my experience, I agree with the court's comments and have used special masters in I don't know how many dozens of cases, complex cases over the years. And I do, and this is just my opinion, view TikTok's opposition more maybe in terms of the timing of the
Pause you for a
appointment.
second. I did ask you if you were expecting anybody else, but it does look like you have another counsel that may need to want to appear.
Yeah, it looks like we have Mr. Terzo just showed up. Thank you, Your Honor.
You're welcome to sit wherever you want. Counsel, okay, go ahead.
So whether it's an objection based more on timing or something to do with the pending writ petition that's been argued and submitted, I don't know. Maybe Mr. Williams will be able to shed some light on that today, but in any event, I'll argue the motion. I think it can be fairly brief here. In terms of the motion, the state asked to deem the matter complex under 16.1F. There was no opposition to that. So I think that portion of the motion should be granted. This is clearly a complex case based on the party's joint statements in the JCCR and other obvious considerations from the complaint and the amended complaint. The opposition also failed to oppose the state's request related to the scope and form of the appointment. That's specifically in the motion on the bottom of page 7, top of page 8. That's the scope of the appointment we requested. And we attached the order from the Meta case that is consistent with that scope. So whether the form of the appointment order is exactly the form consistent with Exhibit 1 is maybe a issue for debate. The state's motion was clear on the scope of the appointment sought, and there was no opposition to that scope. So if the court does grant the motion and appoint a special master, we would ask that the appointment order be consistent with the scope requested, which is essentially the pretrial discovery process consistent with the Meta appointment order. And then finally, the last thing that TikTok did not oppose was the appointment of the Honorable Elizabeth Gonzalez. They did purport to reserve a right to object to her or propose additional candidates, but now is the time to do that. The parties have been discussing Judge Gonzalez and I'll just refer to her as Judge Gonzalez because it's hard for me to call her anything else out of habit, but we've been talking about her for months. It's memorialized in the JCCR, which was filed back in July. So if TikTok had some real objection to Judge Gonzalez or alternate candidates, now is the time to present those, and they did not do that. I will note, just from my personal experience from contacting various neutrals in town, there's very few neutrals willing to take on these social media cases filed by the state because of their size, the amount of time commitment, or other considerations that maybe they haven't even shared with me. But it was difficult to find others. I know Meta's counsel tried to vet others in the other case and had difficulties as well. So, Your Honor, I believe those issues are largely uncontested. And so it really comes down to what the court already framed the issue is whether to appoint a special master now. And well, actually, sorry, one other point I just wanted to make. TikTok raised cost sharing. That's irrelevant. That was not raised in the motion. That was not in the Exhibit 1 appointment order that we attached. So I'm not sure why TikTok brought that up. But in the Meta case, that was handled in the CMO. The parties negotiated, talked to the special master or whatever, and we sorted it out there. So that was not raised in the motion. I don't think the court should be getting into cost sharing by something that's brought up in the opposition and not by way of a counter motion. So to the crux of the issue on whether the court should do this now or later or at all, I'm not sure TikTok's exact position on that. But the main argument that TikTok makes is pointing to Rule 53A2B. And because it's not by stipulation, the court has to make essentially a finding that a special master is needed to, quote, address pretrial or post-trial matters that cannot be effectively and timely addressed by an available judge. So I'm going to kind of put a pin in that question for now, because the TikTok's entire argument or opposition to whether the state meets that standard is framed around 3 cases, and the court, I think, was referring to some of them. One of them was from before I was born, the in Ray Estate of Ray from 1963. And then there's Russell v. Thompson from 1980 and Venetian Casino Resort from 2002. And what's interesting about these and why they don't matter for today is they were all resolved under the old version of Rule 53. And Rule 53 was significantly overhauled in the 2019 amendments to the NRCP. And in particular, there used to be, and this is confirmed in those 3 cases, the Supreme Court in those cases were dealing with the rule that said a reference to a master shall be the exception and not the rule. That's actually quoted and referenced in 2 of the 3 cases, not in Ray Estate Ray. But that was the rule at that time. And that language has been deleted from Rule 53. And I think that's important. Second, all 3 of those cases were decided under the rule subpart that said there had to be some exceptional condition to require appointment of a master. Well, that has now been moved to 53A2C, the exceptional condition language, and the state is moving under 53A2B. So the exceptional condition requirement does not even apply here. That's the standard the Supreme Court was dealing with in these 3 cases. That's not the standard that this court is dealing with for the state's motion. So I'm happy to address those cases more, or those points more, but essentially summing up, those three cases were decided under an old rule and a different standard that don't apply here. And they're a higher standard. So here, we're really just left with 50 through 53, A2B, which says the court has to decide whether the matters being assigned to the special master cannot be effectively and timely addressed by an available judge, which is your honor. And only this court knows its caseload, but we did cite in our reply Chief Judge Weiss's testimony and some of the statistics that were reported in that article. I don't have personal knowledge of them. We tried to find more information on the short clock we had for our reply, but I think litigants in this district have known for years that our state court judges have large dockets, and the fact that the chief judge is up testifying to the legislature just earlier this year that we needed 10 more judges to effectively administer justice in a timely way for litigants in the district, I think signals something. So I think it's really this court's discretion. This court would need to make such a finding and find some basis to say that a master is appropriate under 53A2B. I think just the type of case that we have, the type of issues in terms of the number of documents, there's been no productions so far. There's the discovery only stay that's been entered, so that's why. But all we know from the state side is part of the multi-state pre-suit investigation of TikTok. TikTok produced 119,000 documents. So that's what we have to date. We have 5 defendants, some in China. And I don't know, with the public announcement of a sale, I don't know how that's going to play into the case, but I imagine there'll be some work for the court or the parties related to that. So this is a highly complicated case. I anticipate a lot of documents, a lot of witnesses, some abroad, and I think a special master is necessary to effectively and timely address. And just one final point, Your Honor, the state's position in the JCCR sought a fairly aggressive schedule and trial date. And to meet that, I imagine discovery motions needing to be filed on order shortening time in order to make sure documents are produced in a timely manner, privilege issues are resolved in a timely manner, so that those things do not disrupt depositions that have to happen in order to finalize expert reports on time and get the case ready for trial by the discovery cutoff. So, and back to my comment, only this court knows whether, I don't know if it's 10, 20 plus discovery motions on order shortening time and how that would fit in with the court's schedule. I did have my staff look at this department's calendar for the last 60 days. It seems pretty busy, but Your Honor knows that far better than me. I'm only over here every once in a while, and you're here every day, Your Honor. So there's not much more the state can say in terms of whether Your Honor can effectively and timely resolve all of the anticipated motions and other needs of the parties. But I agree with the court's opening comments. A special master would certainly assist. Access to a special master is quicker and easier in terms of getting quick answers, and whether a party wants to object, they can do that, but often they don't. And then everyone can move along quickly. So that is the state's request. I'm happy to answer any questions the court has.
Well, you picked exactly where I was going to ask my question, effectively and timely. I mean, I think as well, anybody appearing in this court, I mean, OSTs, we get them all the time. Now, do we get a high number of them on Friday afternoons around 3 o'clock? Might be a different issue, right? But I don't think anyone can say that people don't get in quickly in this department. I don't think anyone says I don't set aside time enough for things. I think your 10:30 in another one of your cases evidences that. And that therein lies the challenge, right? Is speaking only for this department, I've handled multitude of issues and multitude of OSTs. Spent days on evidentiary hearings when it's needed for a case, so historically and prospectively, I would have no, historically, it shows what it shows. Prospectively, I intend to continue to do my job, and it's my job, of my job, right? So, and I've been able to do it, so it would be very hard for me, under that plain language to say that I couldn't. Effectively is an interesting word, right? Because effectively is not tied to the idea if somebody decides to file a writ or an appeal or other motion practice, right? Effectively seems to say, do you have the bandwidth to handle this? Well, I have to say I do, because I do. I mean, I've handled things. A timely issue is really a perception issue, because if you're filing the OST, you want it 24 hours. If you're opposing the OST, people want it as long as possible, but that's a judgment call the department has to make to see if it truly is an OST, what is to ensure that there's due process, to ensure everyone has a full opportunity to respond to the extent that they choose to, right? And not, cut off somebody's rights to do that. And then, as you know, and it's happened in this case, because ironically, in this case, I believe there was 100 and, let me state, I think it was 181 entries. Yes, 181 entries in this case prior to this motion for special master. So it's not as if you all haven't filed a lot of things, right? And at a very early stage in the case. So that balances it, but it has shown, at least in this case, hopefully in every one of my other cases, that the court utilizes its bandwidth. Now, whether that means I'm working every night and every weekend is what I do, but therein lies the challenge. I mean, and so I'm kind of saying that in the sense of, how can I, when history has shown that I have time, if I'd seen someone in the pleadings that, look, you tried to get in, you couldn't get in, I'd be evaluating that. If I was seeing that somebody's saying didn't allocate the time, well, I give special settings all the time. Now, we have to balance that with trials and stuff, so parties, might have an option 1, 2, or 3, which is why you give options, but guess what? You all have schedules and you're giving your options anyway, so how does the court address that? That's the reason why I said this has been a unique issue, where someone really hasn't brought this up, right? And I will note on the other flip side, right? There was a statement made in the opposition that you all filed this in business court, knowing that business court judges do discovery. But then if you also look at the statistics and the number of business court cases that have special masters, I think you'll see a particular picture. But then nobody objected to it being in business court. UDCR 1.61 gives rights. Nobody exercised those rights. Nobody said that this wasn't a case that should be in business court. So this one's a little interesting. So I'm giving kind of a long intro, but how would you respond to that? And don't worry, I'm not going to take it personally what your comments are. I don't. So.
Well, thank you, Your Honor. Let me address your last point first. TikTok's point that the state filed in business court. I think they followed that point with that. Well, then we have to be subject to the default rules of business court. Well, Rule 53 is one of the rules available in business court. So I don't know that really matters. And frankly, other than construction defect specialty cases, which were very common a decade plus ago, I think business court cases in my experience, tend to have special masters more frequently than general civil or other types of cases.
The statistics show what the statistics show, and the state has the better argument on that one. Yes, on true business court cases, yes.
But in terms of the standard under 53A2B, effectively and timely, I certainly cannot say, and the state did not argue, that this department has never been unable to keep up with any of my cases or, to the best of my knowledge, any of my co-counsel's cases. So this department is certainly working very hard to meet the needs of every litigant that is before the court. So I can't say that, but I think this standard is a little bit different in that what we're talking about today, and in terms of the court's comments as well, is looking back at history and what the court has been able to do on other cases. And in this case to date. Now, in fairness, we're at 180 filings in the case, but we haven't started discovery yet. Those are all pleadings related issues and, you know, a JCCR and a Rule 16, order setting a Rule 16, those sorts of things, which is fine. But I think the fact that there's 180 filings before we've even had the Rule 16 conference shows the complexity and the number of issues that are likely to come up. And so I know the court frequently says, you know, we don't have, Your Honor does not have a crystal ball or a magic 8 ball or whatever, can't predict the future. But all indications show that this case will be very complicated, document intensive, involve a lot of issues because there is coordination potentially with other similar litigation pending around the country against TikTok, where we might have depositions being presented to the state from TikTok witnesses or maybe others that the state is being asked to adopt or use in this case. I just foresee a lot of issues. So all the indications are that there will be a lot of issues. I would never say, and we did not say, that this court would be incapable of keeping up with everything the parties need. But at the same time, Your Honor, as far as I know, is human, has the same 24 hours.
The birth certificate says I am, so I think I think we can take judicial notice. If not, you can go down to Sunrise Hospital since I was born here.
Yeah, you have the same 24 hours in a day that everyone else has. You have a single clerk. You have, you know, limited staff, and you have probably close to 1,000 other cases. I don't know. So that's why I kind of phrased it as only Your Honor knows whether that standard would be satisfied and whether you could write an order that you're comfortable with satisfying that standard. And I don't know what else the state can say other than, you know, and that's why we did not comment on it in our briefing. We referred to Chief Judge Weiss's testimony about the state of this district and the volume of cases and the number of judges needed to effectively administer. So
I can speak for this department itself. We are incredibly busy. You can see a courtroom full of people, and even that's not unusual. And we run hearings a lot, mornings, afternoons when we're not in trial, and settlement conferences in addition there too, plus all the other obligations. So I'm in no way saying that I'm not busy. I'm just, from a practical standpoint, I am the kind of person that takes on everything I need to take on. And so therein lies an interesting challenge for a judge to kind of say that you can't take something on when it's, you know, that's normally it's always been the parties, okay, that have requested it, and there's been an analysis. That's why, like I said, it's a unique issue.
it is a unique.
Addressing this.
Yeah, it's definitely a unique issue. I think the only other point I would make, Your Honor, is a lot of large companies are relocating to Nevada. They're incorporating here. I think business court will be getting more and more busy in the years to come. The Supreme Court recently set up a committee to evaluate proposed Supreme Court Rule 254 on establishing a separate business court to deal with the volume of anticipated business court, existing and anticipated business court cases.
Talking about yesterday's
There's a
KT that came down, yeah.
Yeah, there's a lot of things. I went to the public hearing on it, and Chief Justice Herndon explained the need and the process in the committee, and I believe Mr. Williams may be on the committee, so he's well aware of the committee and what's going on. But my point is, and I don't know all of the companies, but I did meet with a business law professor from Boyd the other night, and he listed off some companies that relocated. So it is happening, and there is a push to get more companies here. And as that happens, there will be more activity in business court, not less. So plus the growing valley. And that's why this is a difficult one, because it's really looking forward. I don't know how long the stay will last, but I don't know if the state will prevail at the Supreme Court. But if we do, I think we're looking at a 2 or maybe 3 year horizon for this case. And what is the state of this department 2 or 3 years from now? Nobody knows, but we have some of the things that I mentioned that we could kind of look to and decide how busy this department might be and whether the standard would be met.
Okay, appreciate it. Thank you so much. Okay, counsel.
Good morning, Your Honor. I'll start by saying I'm not sure if it's ever good to be the first one to present a new issue to the court. So for better or worse, I guess here I go.
Let me be clear, it's not new, it's new for a case of this size. I don't
Sure.
think you'll disagree that this is you all have put specifically in pleadings, right, with all your extension requests, et cetera, because of the breadth and depth of the case.
Sure.
So I'm really citing you all on you
I
on the breadth and scope of this case, right?
Right.
Publicly available pleadings. Go ahead.
get it, Your Honor. And I was, had a presentation to sort of go through and all the points, but I think everyone has kind of crystallized what the issues are. So let me just maybe talk about some practicalities. And I think, in all fairness, I think Mr. Guyan in many ways drove the point home better than I can do in my own argument. And that is, he ended saying, quote, "Nobody knows." And Judge, that applies to so much about this case right now. And that was why when we wrote the joint letter to the court after our last hearing, the position that the defendants took on the special master motion wasn't like, deny it. It was, we think it's premature. Let's get some guidance from the Supreme Court about what this case is going to look like. We can come back and deal with it. In the end, that's really kind of where I land today, which is to say, yes, we've opposed the motion because the state required us to oppose it, or, required us to take a position on it, and we've opposed it for the time being. If this case comes back in whatever form it comes back, and we then proceed through discovery, and it turns out that we are having frequent, protracted, discovery disputes that the parties can't work on themselves or present to the court, then okay, maybe a master makes sense when we all have a better sense of what the playing field is. When you look at the cases cited by the state in their reply, all of those cases, or the majority of them that are addressing this feature of the argument, they enter special masters when the cases have been going on for a while and it has become clear there is a need, necessity being the key word, for a special master. We don't know that yet. This court is exactly right when we're talking about, can you effectively and timely address issues? Absolutely. We all know that the court can. Its staff and Her Honor work very hard to make sure in whatever cases, these other cases, that we get matters heard timely and effectively. Now, could there come a point in this case where the court and its staff is overwhelmed with the number of disputes and says, time out, I can't effectively and timely address them? Maybe, but right now it's just speculation. And so really, Your Honor, where I come down, and I can talk about the argument under NRCP 53 that a master, the finding has to be that it is necessary, not desirable, but necessary. And there has been no showing yet that it's necessary. The burden is on the state. We haven't consented, so we're not in that paradigm like they are in Meta where everyone agreed. And so I would go back to, Your Honor, but we can come back and address this when we all have a better lay of the land. But in terms of a couple of the points that the state said that TikTok has conceded, I want to go through those about, NRCP 16.1F and declaring the case complex. To be honest, I thought we've already been treating the case as complex. The court and business court automatically issues a Rule 16 mandatory conference, which we'll have after the stay is lifted or at some point down the road. And I'm not saying it's going to stand up here and tell you the case isn't complex. Of course it is. I mean, that's undisputed. But the key point there, and while the Russell case may have been decided under the prior version of NRCP 53, I don't think any courts have retreated from the position that complexity does not justify the appointment of a special master. It can be a factor, but that alone doesn't justify or make the appointment of a special master necessary. With respect to the scope of the order being sought and saying we waived that, I understand they want a special master on pretrial discovery, and then if you look at 7 and 8, it gets kind of vague. And it just says, other pretrial matters not reserved for the court. Well, I don't know what those are. They haven't identified any. It's just sort of this nebulous request. And I think our opposition to the motion is sufficient to oppose that. We specifically said if the court is inclined to appoint a master, then we will want to weigh in on what that appointment order looks like. And with respect to Judge Gonzalez, Your Honor, looking around the courtroom, I don't know who has spent more time in front of Judge Gonzalez than I have. I mean, I had a case in front of her for nearly a decade where I met, in her department at 8 o'clock every Monday morning for 10 years. So I'm very familiar with Judge Gonzalez. I have tremendous respect for her. We're not saying no to Judge Gonzalez. Our position, because the state required us to take the position, is we're opposing the appointment of a special master right now. But what we're really saying is we think we should wait before we make the decision. And I'm happy to meet and confer with Mr. Guyan and talk about, special master specifics and the identity of a special master. But I think it's premature to do it this time. Same with the costs. Mr. Guyan says that I would raise it as a counter motion. I frankly am puzzled. Page 8 of their motion says the state further requests that special master fees and costs be shared equally by the state and TikTok. To which we said, we're not the ones asking for the master. We would reserve the right to say that maybe costs should be allocated a different way if and when we get there. Again, I would submit that we're not there yet. So, Judge, I'm happy to address any questions that the court specifically has, but I do think it goes back to the subpart of the rule that we're operating under, which is there an ability to make a finding that this court cannot address pretrial or post-trial matters in an effective and timely manner by an available judge? I would submit that as we sit here today, the answer to that question is no. There has been no such finding, and there's been no evidence to back that up. If that changes down the road, I'm happy to come back here, or maybe avoid coming back here and try to work something out with the state before we have to do it. But happy to answer any questions.
Okay, so with regards to, as you kept saying, kind of not right for today, but yet you've opposed it. Do you all want a few minutes in the hallway to see if you want to come to some agreeable timeframe if this possibly gets revisited after there's a determination by the Supreme Court or something like that? Or is that ship sailed? Because where I'm going is you're kind of asking the court not to rule, right? In essence. But normally with a motion before the court, right, the court has to.
Well, I think it would be
Deny it.
I think be it denied without prejudice, and we can come back. We have a status check set from whenever your order was entered on the stay motion. We had a 6-month status check because the court made clear, and I respect this, that the court said, I'm not going to grant you an unlimited discovery to stay until whenever the Supreme Court rules. I'm going to set a status check for 6 months and see where everything is at. Makes perfect sense to me. Like, happy to talk with Mr. Guyan in the interim. We have 2 other outstanding issues that are supposed to be negotiated, the ESI protocol and the stipulated protective order. I know that's coming up, but it's not as if we, are shutting it down and we're not going to talk to the state for the next 5.5 months or whatever the case may be. So it does strike me that from an efficiency standpoint, it would make sense to deal with all of these issues when we all have a better lay of the land.
Counsel for the state, would you be, I'm trying to see if there's maybe an agreement between the parties. Would you be amenable if I defer ruling this until February 24th, 2026, when you're coming before this court for the status check on the discovery stay? Or do you want a ruling today? It's your motion. So if you want a ruling today, I'm going to rule today. We haven't had a chance to give your final words. I'm just, in light of counsel's comments, I was just seeing if there was an agreement between the parties. If not, you get your last word. What would you like to do?
Well, I'd like to confer with my client, so I don't know if the court is willing to.
Well, I'm
give
sure
a
there's
short
people
break.
that would like to have their matters heard and recall you all in a few minutes, being my euphemistic term when I finish a couple other matters. Would that work for everybody?
It works for me, Your Honor.
Okay,
Yeah.
then let's do that. Okay, so now it looks like I have TikTok back, so let's circle back please to pages 3 through 6. And if somebody else would like to make an appearance, because we've added some people, feel free to do so. And then we'll handle what you need to handle.
Good morning, Your Honor. I new appearance, Will Sykes, bar number 9916. I appeared earlier, Your Honor, but I didn't want to interrupt the argument, so I waited in the hallway.
Yeah, no worries. You're more than welcome to make an appearance, and I just didn't want anyone to feel left out.
Thank you.
Okay, anybody else on defense side that needs to make an appearance?
No, Your Honor.
Okay. So, we mentioned this is pages 3 through 6, case 886167, State of Nevada versus TikTok Inc. So, counsel, you're standing up. Feel free to say what you'd like to say.
Yes, Your Honor. Thank you, Michael Gain for the state. The state would like to, in light of all the circumstances, have the motion that is set for today that we just argued, continued to the status check in February 2026 with a couple of caveats. First, Mr. Williams offered to meet and confer on these issues between now and then. So the state is taking him up on that offer. And I spoke with him during the break and he's agreeing to maintain that position. Also, state reserves the right to ask that the motion and the status check be advanced should the Supreme Court rule on the writ petition and remitter issue before that time, materially before that time. You know, if it happens shortly before, we probably just stick with it. But state just wants to reserve the right to move it up instead of waiting.
Counsel, for
All
defense?
of that's accurate, Your Honor. We agree.
Okay, so the court's going to take in, well, I've had the oral argument. We're just going to move the. All right, is anyone going to ask for additional oral argument on February 24th? I'd rather just address that right now if you are or not, and if there's an issue on it.
Your Honor, I think it would make sense to have the ability to talk about this some more on February 24th, depending on how the meeting and conferring goes. It's possible we could narrow the issues. Maybe, I don't know exactly how that will turn out, but
Does that work for you, counsel for defense?
Yeah, what I was gonna suggest, and I'm happy to talk with Mr. Gann about this, but maybe a status report before indicating where the parties stand can frame it, and to the extent we need to talk about whatever's in that status report, Your Honor, that would maybe help educate the court in advance and narrow what we need to talk about on that day.
I think that makes a lot of sense. Maybe a week before the hearing, we can do a status report and indicate whether we want any time to complete arguing the motion. I'll note I didn't give another vote. But whether we need time.
That's why I was intentionally making sure, because I wasn't sure if you were going to tell me you were reserving your rebuttal time until February. So that was a very open-ended question for that reason.
Yes, but the joint status report could inform the court whether the parties have reached any agreement on the special master issues, also the ESI and the stipulated protective order issues, and indicate just my experience with the department. I anticipate it would be helpful if the parties gave an estimate of how long we might need to deal with any open issue.
Does that work for counsel for defense?
Agree with all that, Your Honor.
Okay, since the week before is actually President's Day, let's say February 18th status report due to the court, right, by end of business day. And I think you've anticipated what I was going to ask you. My next question was going to be February 18th, 2026, end of business, whoever needs to do whoever needs to do. I was going to ask you, did you need me to address the other two issues today, or were those also going to be?
We'll lump those in, Your Honor.
So those were also, okay, so by mutual agreement of the parties, in the letter dated September 5th, the outstanding issues regarding, on the September 5th letter will also be addressed on February 24th. If the parties still need that to be addressed on February 24th, the court notes that if there's a decision from the appellate court prior to that, and if either side requests that I advance the status check or advance the hearing on these other motions, then the court will take that into consideration or receive such requests. Does that work for everybody?
Yes, Your Honor.
Okay, and then if there's nothing else, I'm gonna, now, Mr. Gann, I assume at this juncture, you're not gonna are you going to request that you want your rebuttal argument now? And then I can continue it, or you want to just hold that in your pocket?
I had some really good points to make, but I'll save them, Your Honor.
Okay, so then we're gonna, court made no rulings, so the minutes are gonna reflect based on the mutual agreement of the parties. The ruling and additional oral argument to the extent necessary is going to be February 24th, 2026, the time of status check, unless if it's otherwise moved to a different date, either by request of the parties or by the court's own determination. Does that work?
It does.
Yes, Your Honor. Thank you.
Thank you so very much, everyone. See some of you in a